Good morning, everyone. We are waiting for Chair to connect. Thank you.
Good morning, honorable members.
Recording in progress.
The department is led by the minister. Please bear with me. I'm trying to use my iPad this side, but in the meantime, for net I'm using my smartphone. But when I get through with the iPad, I will switch. But also, I am on the road, but will do my level best. Are there any apologies?
Good morning, Honorable Chair, Honorable Members, and our Honorable guest. I've got an apology from Ms. Madokwe. She's not attending the meeting. And Mr. Zungula is attending another meeting, Chair. Those are the only apologies, Chair. And sorry, and for Ari, he's not attending the meeting. Thank you, Chair.
Oh yes, I did receive the apology from Ari, and I think it's important to extend our condolences to him. He lost his aunt this morning, and he's attending to that. That is one part. I think, honorable members, we all know that today we are meeting to deal with the issue of the. Am I still audible? Am I still audible?
Yes, Chair, you are.
Oh, okay. I'm saying today you are dealing with the issue with regards to the presentation made by the department on the risk mitigation independent power producer purchase. And members had raised areas of concerns, especially with the subsequent allegations that were made. It was therefore agreed that we need to tackle this matter and also get clarity on the purpose, cause, and context of the project. In that regard, the normal procedure, therefore, is to get a general briefing from the executive authority on the basis of his or her executive actions. And subsequently, we then start the process, setting up the process on how to handle the matters, including the approach that the committee would like to take. And therefore, we are dealing now with the initial or the first phase of the inquiry. And we will then go in detail subsequently when we have cleared most of the issues with the executive authority. It is on those bases then that we have invited the minister in his capacity now as Minister of the Department of Mineral Resources and Energy, to brief us in terms of the context, the origins, the basis, as well as the allegations that are in the public domain. And then on the basis of that, we will give honorable members an opportunity to ask questions of clarity. Let me appeal, I know sometimes case matters of this nature, they tend to have some degree of emotive. Let me appeal that whatever we do, let's do it within the confines of the jurisdictions of a committee of parliament, and do it with ultimate commitment to resolve the matters. In that regard, I will give the Honorable Minister, on the basis of what had been requested, to give us a brief understanding and also the ultimate decisions that were made with regards to the risk mitigation and independent power producer purchase. We will then give honorable members to ask questions of clarity. And let me say, therefore, I always state that I am a chairperson, I'm not a mediator. So let's make the work much more easier. Let's deal with the content. Let's put aside, I'm sure all of us, when we come to a meeting, we have got a thinking of what we want to achieve, what do we have in our minds. Let's leave who has got what and deal with what we think, or what we think are the questions that are necessary, if there are any that need to be answered. In that regard, let me give the minister the opportunity then to brief us about the entire process and the procedures that were followed in dealing with those issues. Honorable Minister, the floor is yours to brief the committee. Thank you very much.
Thank you, Mr. Chairperson, honorable members, our whip in the committee, everybody present here. First of all, Mr. Chairperson, let me record that portfolio committees on Wednesdays clash with cabinet meetings. I had to come out of the cabinet to come to the portfolio committee. It's a very awkward arrangement because all the time we put pressure on us. We have asked the Deputy President to talk to the Speaker of the House to at least coordinate and make that clash to be avoided as much as we can, because it makes people who are supposed to come to portfolio committees and they're members of the cabinet to throw a coin and choose what happened. In other portfolio committees, it's quite tense because it happens almost every week. But I'm putting that on record, Mr. Chairperson, so that we have 7 days a week. I work on weekends. If the portfolio committee calls me on weekends, I will be here. So Wednesdays are quite awkward days for a cabinet member, whoever that is. Okay, let me come to the item. The risk mitigation independent power producer program, purchase program, is a long one, RMIPPPP. It's quite a difficult issue. One, I want to start by the fact that whether it was necessary to have the RMIPPPP, the integrated resource plan recognized the supply demand created by challenges with ESCOM, a generation plant, and calls for urgent procurement of additional capacity, with project lead time being critical. Now, if you take that, it means it's a response to the problem of ESCOM to have this program. So therefore, the necessity of that program, at that time, the RP estimated the supply gap to be between 2,000 and 3,000 megawatt. Now, ESCOM has recently indicated that the gap is over 5,000 megawatts. due to continued deterioration of plant performance. In other words, the electricity availability factor, the plant availability factor is worse than it was. So this program supplements ESCOM on that issue. So from where was seated, that necessitated this program. Then in December 2019, the DMRE issued a request for information aimed at gathering information about available capacity that can be urgently procured and brought online in less than 18 months from contracting. Now, the RFI, which is the request for information, is quite a critical stage in the process of procurement, in the sense that it is beginning to talk to the market and test the market. And therefore, it's a transparent process that tests the market. And what came out of the RFI was that there's limited capacity from existing projects that can be enabled through require short-term contracts. There was very limited capacity to meet short-term contracts. And there are projects that can come online in 12 to 18 months, but will require long-term power purchase agreements as they are greenfield projects. And that means they're not brownfield projects, they are not existing projects. They will be started from scratch. For available capacity that requires short-term power purchase agreements, the following procurement programs were initiated. One, ESCOM short-term power purchase program, which is not this program, it's another program that is aimed at supplementing the shortfall. Procurement of available additional capacity from existing renewable energy. There was a loud noise that said there is idle capacity of IPPs that was out there, not used. And we created a program that said, please procure that existing capacity because it will help us reduce the shortfall. And then for capacity that required long-term power purchase agreement, the Risk Mitigation Independent Power Producer Procurement Program was initiated. This is therefore the basis for this program. So I'm giving that a basis because when a program is covered in a cacophony of noise, it loses its essence and its context. Then I'm giving that background so that we all understand. Having agreed on that, on February 2020, the minister issued a Section 34 determination for RMIPPP to NERSA for concurrence. Now, you know, I always say this thing that as a failed accountant, I always respect one principle about accounting, that no transaction must be handled by one person from the beginning to the end. Therefore, this principle is very important when a Section 34 determination is issued. It is issued to NERSA for ERSA to concur, so that it is not a monopoly of the department or the minister to drive a program. And then on the 22nd of May, we received the concurrence. And on 7th of July, we gazetted the Section 34 ministerial determination. And the 2,000 megawatt ministerial determination had two objectives. One, to procure new generation coming from a range of sources of technologies to address the electricity capacity supply gap as identified in the IRP 2019 within the shortest possible connection timeline, and to reduce the extensive utilization of diesel-based peaking generation in the immediate to long term. And I'm coming here with Mr. Mugoro from the IPPs, because I want him to explain to the committee the technical aspect of the program and say, this is what happened in practical terms, so that the myth that has been created around the program can be demystified and we deal with issues that are real problems. So, in February 2020 to August 2020, extensive discussion were held with stakeholders on key elements of the RFP, though that included technical arrangement requirements, risk allocation, and government support. The stakeholders included ESCOM, included National Treasury, included DPE, and included NERSA. And 24 August 2020, the department issued the request for proposal. That is, 24th August 2020, a request for proposal was issued for new generation, again, out in the market. On 22nd December, bid submissions were closed. Now, on 18 March 2020, 11 preferred bidder projects total to 1,995 were announced, but 3 of which needed further engagement to improve value for money and their proposed tariffs. Now, that was important in the sense that when we announced the winning bidders, which I do, I know that when I announced the bidders, immediately the ball is smashed at my court. That day I announces preferred bidders, therefore it is broken. That's why the questions that have been in the media about our involvement actually missed the point. For example, whether I can extend time for bidding. After I'm not running the process, I can't do that. Number two, all those questions. So, for example, when a person writes in court and saying, I received information that somebody else, name not mentioned, talked to the minister's wife, and there's a WhatsApp message that says she confirms that there will be extension. Now, it's an issue that is in the newspaper. It dents your public image. But the reality of the matter is that this person talks on third person, but in a strong statement. But that is a subject of the court process. It's not for us to determine, so no, allow the court process, because we're hoping that in that court process we'll be able to say, X received this call on this date from Mrs. Mantashe, which in reality does not exist. Now, the MR is the procurer in line with section 34 determination. This was the department SCM processes in line with PFMA, and the department is responsible for implementation agreements and management of this contract. ESCOM, the buyer, in line with section 34 determination. ESCOM, the system operator, specify technical requirement for the RFP, and ESCOM, the system operator, entered into a power purchase agreement with IPPs. And National Treasury provides ESCOM with guarantees in line with the agreed risk association. So basically, there's a whole string of players in this transaction. IPP office manage and coordinate procurement of power on behalf of the department. And I want to give Mr. Magoro, the head of IPP office, to actually take us from this point and be able to move with all the technical aspect. For example, the department mandates the IPP office to assist with development of the RFP, the management of the procurement process, and the evaluation of the bids. And the IPP office use independent financial, economic development, technical, legal, and guarantee transaction advisors in development of the RFP and evaluation of the bid. That is the office that does that. It's not the department or the ministry. But I want to hand over to Madam Goro to take us through the general aspect of the process. With your agreement, Mr. Chairperson, I would ask Madam Goro to take from here.
Thank you, Minister. Good morning, the Chairperson, the members of the Portfolio Committee, and the other audience that joined us this morning. My name is Bernard Magoro. I am the head of the IPP office. I was overseeing the process for the procurement of the risk mitigation IPP procurement program. I am going to take you through the process that we followed. In the previous slide, the minister showed that we are responsible for the procurement on behalf of the department. The way the process works is that we get an instruction from the department. Once the determination has been concurred by the regulator, as explained by the minister, we will then run with that process until the evaluation process is completed, whereby we then go back to the department for approval and finally the announcement of the preferred bidders. So I will explain how the process works in the next few slides. But just starting with where the risk mitigation came about, the gap that the minister spoke about was identified in the IRP, and the decision for this particular procurement was to procure 2,000 megawatts, and the requirements, and this is more important, the requirements in terms of the technical capability of those projects was specified by Eskom system operator. The reason for that is they are the ones who will be making sure that these plants are supplementing whatever the shortfall is on the grid. So they specify what the system requires at the time. Bullet number 2 is just explaining some of the requirements that the system operator specifically asked for. Energy is the units that we use to operate any electrical equipment. But what is different and what is important here is they've also asked for capacity. Capacity means that that energy is available when you need it. So when we go out to procure, we had to make sure that we specify that it's not just the energy, it's also the capacity. I'll come back to this point again later. Lastly, there was a requirement for ancillary services. Ancillary services has to do with responding to the grid dynamics. So if another unit drops off somewhere else, these projects had to have the capability to be able to increase or reduce capacity in response to those changes on the system. Those were the key requirements that the system operator prescribed for this program. And this, if you recall, the program asked for capacity to be available from 5 a.m. in the morning until 9:30 at night. And we went out to procure on that basis. Other requirements, in order to meet that requirement of the system operator at a competitive price, we allowed projects to bid either a single dispatchable project, if there is a project that can meet all the requirements that the system operator specified, that project could be as a single project. We also allowed projects to bid as a portfolio of different facilities, whereby you could have a dispatchable project and a non-dispatchable project be together as one. Where this becomes advantageous, Chairperson and the members, is that we know that the non-dispatchable technologies like your wind and solar are very cheap these days, whereas your typical dispatchable project like coal or nuclear or gas or hydro are relatively expensive compared to non-dispatchables. So what this program allowed us to do is to, it's for a bidder to combine a dispatchable and a non-dispatchable project as one project, so that we evaluate them as a single project. That way, they are able to reduce the overall price of the portfolio of the projects that are bid together. So I hope this is understood, because it will become clearer as to why we ended up with the combinations that we had. And the other important aspect here, there's been a lot of media writing about the charging from the system. ESCOM made it clear in their requirements that they do not want any projects to have the capability to charge the battery, in this case, from the existing facilities. So they said each project must make its own arrangement regarding the charging of its own facilities. Where this becomes important is we do have projects that have proposed a combination of renewables and battery storage. So what that bullet number 3 entails is that whoever is putting forward that bid has to make sure that they have provided facilities to be able to charge that battery from that particular project. And then in the end, we had each project providing a tariff, and all in all tariffs taking into account, next slide please, taking into account the construction costs, performance of the plant, fixed costs, variable costs, O&M. So when we evaluate these prices, it's after we have evaluated all the different cost components and come up with a single all-in tariff where we are able to compare each of the projects against the other. So the other point to keep in mind, I think the minister touched on the RFI. The indication from the RFI was that if you go for a shorter term PPA, a 5 years or a 10-year or 15 years, you will pay more in terms of the tariffs. Because what happens is all the capital investment, and this is the message from all the lenders as well, they need guarantee that they will be able to recover all their investment. And the shorter the period, it means that that investment will have to be recovered over that shorter period. As a result, the tariff goes up. So the 20-year PPA term was decided upon based on the RFI from the market, which indicated that the 20-year, it also aligns with most of the lifespan of the, especially the renewable technologies. And that's where the 20-year PPA term comes from. So should we have gone for 10 years or 5 years, I can assure you the price would have at least double or triple or even quadruple if you're looking at a much shorter term like your 5-year PPA term. And I must also emphasize, listening to some of the questions raised, as part of this program, each project has a 20-year lifespan, and they have to make provision to demolish that project and clear the sites at the end of that 20-year term. Whether you're building a PV plus battery or you're building a gas plant, there is a requirement in the implementation agreement to have a guarantee or demolishing trust that, or rehabilitation trusts that will be utilized to clear the sites. So it's not as though these projects, some of them will disappear at the end of the 20 years while the others will stay. All of them are required to clear the sites at the end of the 20 years. In terms of the project or the program, we said commercial operation must be achieved within the period of 12 to 18 months. And after 18 months, there are strict penalty mechanisms whereby the projects are not allowed to proceed with construction. If the project is not completed within 18 months, whatever has been completed at that time becomes the declared capacity, and that is what they will be contracted on for the full 20-year period. So there was a very strict requirement to complete the project within the required timeline. As you will understand, this is an urgent procurement which was meant to plug the gap that was identified in the IRP. And then in terms of what we do in the IPP office, the minister has already alluded to the point that we have capacity in the office, but most of the work is done by the transaction advisors. So the program is structured with 4 key disciplines, one being financial, the other one being economic development, which is meant to address the transformation agenda by the department. And then you've got the technical discipline, which is largely what the system operator within ESCOM specify. And then lastly, because these are all legal agreements, we do have legal discipline as part of the RFP and the procurement documents. So we appointed technical advisors along the same lines as the disciplines that we have structured for the RFP. And if you look on the left-hand side, these are the technical advisors that we utilized for development of the RFP itself. And on the right-hand side, we used a separate set of transaction advisors for the evaluation of the bids. If I can just start on the left-hand side, for financial, you will recall that some of them we paired them. So there was a requirement as part of skills transfer and bringing in more emerging firms, that if we appoint a large firm, we would want them to team up with a smaller emerging firm as a way of facilitating the transfer of skills. As you can see, the Ernst & Young in the development of the RFP were teamed up with Ramwe Zisi. Lidova Mazwai, it's a transformed BE firm, compliant firm, and therefore they were able to proceed on their own. And then technical, we had WSP and Amandla teamed up with Amandla, and legal advisors we have Weber Wenzel as well, which is a level 1 BEE company. On the right-hand side, you will also see the same structure in terms of the appointment of the TAs. So these TAs are the ones who are responsible for these particular aspects of the program, the development of the RFP, as well as the evaluation of the bids when they come in. We as the IPP office project manage this whole process, but the transaction advisor signs off on the work that they do. And then on the evaluation side, we also have an additional governance technical advisor who overlooks the whole process of evaluation. There is a separate report that confirms all the interactions that happened within that evaluation process. So it's very difficult to influence this process from outside. I think that's the one point I should highlight, because all these different TAs have a separate scope of work that they have to deal with, and they issue a separate report on that particular scope of work as they evaluate. And then those are the reports that then gets presented to the bid adjudication committee for approval, and thereafter to the Director General for sign off. I must emphasize that during the RFP development and the evaluation of this particular program, no change was made by ourselves as the IPP office. No change was made by the BAC. They have reviewed what has been done. They were happy with the work that has been done, and they recommended to the Director General to approve the outcome of that process. And that is what was presented by the Minister as the final list of preferred bidders. Next slide. Okay, so this is just highlighting that as we develop the RFP, we do, and I think the Minister touched on this, we do comply with the supply chain policy that the department has. And part of that is to make sure that we go back to the department for approval of the RFP before we go out to the market. Once again, the bid adjudication committee made no change to the RFP itself, nor did they make any change to the bid evaluation report that came out of the transaction advisors. Also, the other point that I should have highlighted in the last slide is that the appointment of the transaction advisors, we operate under the Memorandum of Understanding between the Department, National Treasury, and the DBSA. The appointment of transaction advisors is independent of the department. In that process, we follow the DBSA supply chain policies. And there is no influence from the department whatsoever in the appointment of the transaction advisors. Next slide. Next slide. Sorry, okay, thank you very much. So this slide is indicating the evaluation process itself. We have two stages of evaluation. The first one is the qualification process. And we have, as I mentioned earlier, the 4 disciplines where we've specified requirements for technical, financial, economic development, and legal. And those requirements have got set criteria whereby if a bidder does not meet any of those requirements, it's a pass or fail criteria. If a bidder does not meet any of those requirements, they cannot proceed to the next stage where we evaluate the bids. And that is a very important aspect to understand. The qualification stage is a pass or fail. So we've got a list of requirements based on those 4 disciplines. We'll get to that in the next slide. If a bidder fail on any of them, we've just listed a few here. For example, the minimum 49% South African entity participation. If a bidder does not demonstrate that there is 49% shareholdership by South Africans, that bidder is immediately disqualified. Similarly, if the bidder does not meet any technical or environmental or land use requirements, they will not pass that first stage, and therefore they will not proceed to the next stage. So the next stage is where we then rank up the bidders based on price, which counts for 90%, and the cheapest, the bidder who offers the cheapest price gets the maximum price. And then all the other bidders, as we start going up the merit order, they then get allocated points relative to the cheapest bidder. And then the 10% comes from economic development objectives. I'll talk about that economic development objectives. In this program, bidders were allowed to compete on contributions to economic development scorecard. And the bidder that contributed the most gets the most points. And that's where the 10% comes in. So once we have finished the ranking of the bidders based on those two components, we then look at how many of the bidders make it to the 2,000 megawatts that we were procuring in this program. In this case, if I can start with stage 1, we received 28 bids. 11 of them did not make it through stage 1. So they failed stage 1 for different reasons. And the 17 that made it to stage 2, 11 of them made the cut to contribute to the 2,000 megawatts we were procuring. So anyone that falls outside the 2,000 megawatts in terms of the point system, those bidders were obviously not considered. And I must emphasize, in this program, there was no reserve bids. So the requirement is that all the 11 bidders have to meet financial close. Any of them that if they don't reach financial close by the set date, what happens is that the bidder fails to reach the contractual agreement. So we're not going to sign the agreements with those bidders. So all of them are expected to reach that or to achieve financial close and meet all the outstanding requirements as per the RFP. And once they have reached financial close, then they will sign the power purchase agreement with the buyer and the implementation agreement with the department. The implementation agreement monitors mainly those the economic development objectives that the bidder has committed with the department. And the IPP office has been mandated to monitor compliance with the IA for the full 20-year term. Next slide. Okay, so in this slide, Chairperson, what I've tried is just to summarize some of the stage 1 qualification criteria. This is important. As I mentioned, 11 of the 28 bidders failed at least one of these requirements, which is why they couldn't make it to the next stage. So as I mentioned earlier, technical requirements is mainly specified by the system operator, and this is purely to meet what the grid requires. There is also a grid code that has been approved by the regulator, which specified what the general requirements of each generator connected to the South African grid has to comply with. I'm not going to go into the details of the technical requirements, but it's important to highlight that the system operator required this capacity to be available from 5 a.m. until 9:30 p.m. And this is aligned with the times that we have been experiencing load shedding. And this is why this program was structured in this fashion. It was a technology agnostic, which meant that no technology was excluded from participating in the program, provided they meet the technical requirements and all other requirements as specified in the RFP. The minimum was 50 megawatts, maximum was 450 megawatts per project. And I think on the technical side, that's probably the key aspects that are important. And then on the legal side, legal has got a number of areas which the RFP specified that each bidder must demonstrate compliance to for them to be able to pass this qualification stage. The first one, it's around the project structure. This includes the ownership funding. I've already touched on the fact that we had a 49% requirement for South African entity ownership, and there was a 30% requirement for BEE participation in this program. And then there are also commercial requirements in terms of complying with all the agreements as released with the RFP. The PPA, the IA. So we expected all the bidders who participated to agree to the conditions of those requirements. And then the third aspect under legal, which is also very important because it has been very controversial, it's around the environmental. So for this program, because it was an urgent program, the decision was taken that we need a scoping report for this program. To achieve a full EIA approval, and I think the Department of Forestry, Fisheries and Environmental Affairs can attest to this, you need at least a year. There was no bidder given the agency that we were procuring this program. There was no bidder who would have made it to get the full EIA approval on time. But there was enough time for a scoping report and to lodge the application with the Environmental Affairs Department. That was the minimum qualification criteria for the program, with the understanding that the process will continue while we evaluate and announce. Let's go back to the previous slide, please. While we evaluate and announce the preferred bidders and until we reach financial close. So there was enough time from August last year to achieve environmental authorization approval. But for the purpose of bid submission and evaluation, all we needed was the scoping report. So if we can go back to the last slide. And then the last issue on the legal was around the land use. We specifically stated that we needed confirmation that the bidder has rights to land, whether it's a lease or a full ownership to the land for the use of the project. I must mention here, in discussions with TNPA, and we did issue a specific briefing note in this regard, the agreement was that for ports-related projects, and whether it's for the import of ports or to use the existing terminal operators, the bidder needed to achieve that. Sorry, the slides are moving around. So there was an agreement that TNPA did not want to engage with all the bidders before bid submission. You'll recall that the program was out in the market for 3 months only. So TNPA issued a briefing note through us that they will only engage with the preferred bidders after preferred bidders announcement. And this is why the issue of land was different for those projects that are in the ports. And that is the process that is currently undergoing between the bidders that are going to utilize the ports and the TNPA. So that's on the legal aspect. And as I mentioned, the land issue, because I think it's one of the contentious issue in the case, we needed bidders to demonstrate that either they have a lease, registered a lease for use of the land for the project, or they have ownership of that land that they're going to utilize. And then on the financial aspects, I'll go through this very quickly. The key issue here is to demonstrate that the project sponsors are able to raise funds for the project. We also test the robustness of the funding and the financial model of each project so that we are clear that the project is bankable. And there are a number of returnables, which are confirmations from the banks that they are standing behind the project. And that is the financial criteria for the qualification stage. And then lastly, on economic development, we had set targets, which we developed together with Department of the DTIC and National Treasury, specifically around the BEE commitments, ownership by local participants, ownership by Black people, local content, management control, commitment to support the small businesses, particularly in the area where the project is located, as well as socio-economic development commitments to the local communities where the projects are located. So all of these ED requirements had minimum thresholds as qualification criteria. For example, on the ownership, as I mentioned, 49% for South African participation and 30% by Black individuals. Contributor status minimum was set at level 4 for this particular program. So this is where the 11 of the 28 bidders failed in one or more of these particular aspects. It's important to also highlight that before we made the final decision on the failure points, we even allowed the bidders what we call the clarification stage, where we give them a week to go and verify that what we are seeing in the evaluation or what the technical advisors have found in the evaluation is correct. No bidder is allowed to supplement their bids during that process, but they can direct us in their files where they believe we could have missed any information that we are seeking. And if the bidder is able to demonstrate that that particular aspect has been complied with, we then review that response, and then the transaction advisors will make the final call after looking at that response. But I must emphasize, this is not to supplement the bid. This is to confirm that what the transaction advisors have found is indeed the submission that the bidder put forward. Next slide. Yeah, so stage 2, it's a straightforward process where we then look at the price that's been offered, and we also look at the commitments to economic development objectives, and those projects will then be ranked on the basis of who is offering more in terms of the lower price and more in terms of economic development objectives. And then once we rank them, then we are able to select the projects that make the cut to make up the 2,000 megawatts that we were procuring. Next slide. Okay, so the outcome of the evaluation process is the list of projects that you see on the screen, Chairperson and the members of the committee. We had 11 projects that were appointed for this program, and then you will see the capacity that they offered, as well as the price that they offered us as per the bid submission. Currently, we are expecting these projects to reach financial close by the end of this month. There was an initial date of 31st of July as announced by the minister on the 18th of March. Unfortunately, we were not ready on our side. In particular, ESCOM board has not finalized their approval of the project agreement, and that process is currently underway. And also, NERSA was also still busy with their generation license consultation process. In the middle block, we're just showing some of the commitment that have been made through this program in terms of economic development, the capacity that we're procuring, and the expected investment in the program. What you don't see here, there's 3 other projects which we were still negotiating at the time, but they have subsequently been appointed as preferred bidders as well. So the total number of preferred bidders is 11, and they are all expected to reach financial close by the 30th of September. And then on the in the map, we're just showing where the projects are located, and you'll also see the different technology combination. I mentioned earlier on that the program was structured such that you could have multiple technologies bid as one, or you could have one technology, provided that technology can meet the technical requirements specified by the system operator. So we've got different combination from car power ships that are located in the ports to a project like Mulilo Hydra, which is a combination of PV and LNG gas generators. And then you've got Oya, which is a combination of PV, battery storage, wind, and a small diesel generator. And then you've got other combinations which are purely renewable, where it's just a PV and battery storage combination. So these are the projects members that made it after following the process that I've just highlighted. Next slide. Okay, I think I'm gonna just touch on this as well, because we are also the respondent to this application. So I've mentioned that there were 11 bidders that failed through the qualification process, or they failed the qualification criteria. And there is an entity that represents 3 of those projects, and the name of the entity is DNG Power Holding. And they decided to challenge the DMRE and the IPP office through the High Court application. And what they're challenging is the decision that we made to disqualify them. And they are also basing their application on the briefing notes that were issued. They cited 2 specific briefing notes, and I think it's important that I deal with those in this briefing. Although this matter is still the subject of a court case. On the briefing notes, the one briefing notes they challenge is the extension of bid submission date. On the 30th of October 2020, we extended the bid submission date from the 24th of November to the 22nd of December. The reasons for that extension was purely because the market, and we do have evidence of this, a number of prospective bidders and the lenders requested more time to prepare the bids because of the complication of the program. This program is unique in the way that it's the first time that we are procuring different technologies as one program. We're allowing a combination of different technologies at different locations to be bid as one program. So on the basis of the reasons that were given by the preferred bidders, and this was, sorry, not preferred bidders, prospective bidders, and this was the only reason why we decided to listen to the market and extend that bid submission date from the 24th of November to 22nd of December. There was no influence from anybody except that we received requests and we listened, and this is a normal process. I must highlight that any infrastructure type program or project, it's impossible to have a bulletproof RFP that will not require any clarification. For this program, we received, if I'm not mistaken, close to 1,000 clarification notices. Some of them were a repetition of similar type of questions. And it's normal to issue briefing notes to clarify things to the bidders. Any change that may have a material impact, like the change in the bid submission date, we follow the same governance process as for the approval of the RFP, where we need the BAC approval or recommendation and supported by the accounting officer's sign-off. So we went through that process. The reason we only issued the extension notice on the 30th of October, it's because the process had to be followed to the letter before we could make announcement of that extension. I can also give an example. Even in the current program that we're running, Bid Window 5, there has been request for extension, but when we looked at the reasons, those reasons were not justifiable for us to extend the bid submission date. And largely because we have to balance the fact that we do need this capacity to come online as soon as possible. But if the justification makes sense, for example, in the case of this risk mitigation program, we had to consider that on its own merit and recommended to the department that it is just to allow the bidders more time to prepare the bids. The risk that we foresaw was that we were going to have less bidders participating in the program, which does not help the program at the end if we don't achieve what we're looking for. And then the other briefing note that was challenged by the applicant relates to the local content requirements. The local content requirements are managed by the DTIC and through the circular that is issued by National Treasury. So there are certain designated components or equipment that National Treasury and DTIC have already legislated that they can only be purchased locally. So what DTIC does is that during the RFP in the market stage, they allow bidders who feel that there is no capacity in the market, in the local market, to meet the requirement of the program. Those bidders are allowed to apply to the DTIC, not to us, not to the Department of Mineral Resources and Energy. The DTIC undertakes its own assessment of that application. They look at what the market is capable of providing locally, and they make an independent decision whether to grant that exemption in total or grant a partial exemption. And what happened in this case, they've granted a number of exemptions. They granted an exemption to car powership from local content. They've granted an exemption for inverters for PV panels. And those exemptions, we received them from DTIC for the purpose of communicating to all the bidders. So the arrangement between us and DTIC is that if there is any exemption that is granted, we must communicate that exemption to all the registered bidders so that that exemption become applicable to all the registered bidders. So that I thought I should just clarify that local content issue. So it was not an approval by the department. All we did was to communicate the outcome of the DTIC process. The decision to qualify this particular bidder, again, this is a matter that is before the court, but it's important to highlight that in all our disqualification, as I've mentioned earlier, we allow bidders to confirm that what we are seeing in their bids is correct. And if we are missing anything, they must direct us to where we should find that missing information without supplementing what was submitted on the bid submission date. And the transaction advisors looked at what was responded following that clarification questions, and they made the final decision that this particular bidder and the bids that were submitted failed certain aspects of the qualification criteria. I don't want to go into those aspects, but this applied to all the 28 bids that we received. And in fact, in most cases, bidders that failed in more than one aspect. And without going into details, the requirements are exactly the same for all the bidders. And this information has already been furnished to the court in terms of where this particular bidder failed to comply with the qualification criteria. And then the third one, which is quite strange, was the decision to, our decision to appoint the particular bidder. As I've mentioned, the program was technology agnostic, and the outcome of the process was based on the evaluation that was done by the team of transaction advisors. And we have since engaged the transaction advisors as we're filing the court papers, and they have stood by the decision that we made during the evaluation process. So I think what was also strange was that the application specifically wanted the applicant's bids to be reinstated or appointed in place of one particular bidder. And I mean, members, you will understand that government procurement is highly, highly regulated. It is strange that anybody will think this process is even possible. Even if any of the bidders do not meet the commercial close deadline, do not receive any of the licensing and authorizations that they need to meet that deadline, there is no opportunity in this program to supplement any bidder with the other. If the department decides the only thing that can happen is to go out and procure again, the RFP did not make any provision for reserve bids in this program. Next slide. Yeah, and then as part of that, I'm just talking through this because we had to prepare the responses to the court application. In the application, there was a claim that certain individuals within the department, and I think the minister will come back and respond to this. So in our answering affidavit, through our legal advisors, we asked for the applicant to furnish us with the names of the people involved so that becomes part of the court process. And the bidder did not respond to that request. In fact, they did not respond to that. It was a request through the court process. So that information did not come through by the deadline, and therefore we did not necessarily respond to that. But the minister will come back and talk about this. It has since been established, and this has also been part of the court papers as well, that yes, there has been meetings, and I am not qualified to talk about what happened at the meetings, but all I can confirm to the members of the committee is that from where we sit as the IPP office, there was no influence or instruction or any form of tampering with the process that we were following as the IPP office. In the initial application, there was an interdict application followed by the main case, but subsequently the applicant dropped the interdict, which is why all the projects are progressing with their preparations for financial close. Next slide. So in terms of the case, we have filed all the court papers. By the 20th of August, we filed our heads of arguments through our attorneys and senior counsel. And the case is scheduled for the 9th, 10th, and 13th. So that's next week, Thursday, Friday, and the other Monday for hearing at the High Court. Yeah, so yesterday I received court papers from our legal advisor coming from the applicant. It was an unusual application to court where the applicant is now, after we have all prepared the court papers for the hearing next week, the applicant is now asking the court to postpone the hearing to end of November. And the reasons cited are that the applicant wants the parliamentary inquiry to be concluded first. The NERSA licensing process, I must state that this process, I'm not sure why it was cited. It's a regulatory process which has got nothing to do with the case. NERSA has its own processes. And I don't believe this process should even form part of the court proceedings. And then lastly, we also hear from this application that the applicant wants the police to investigate allegation of influence on the process, which I suppose is the claim that was made in the initial court application. Yeah, and unfortunately, from where we are actually opposing this application to delay the hearing because we would want this program to be concluded as early as end of this month. So as we sit here today, Chairperson, there is a meeting with the judge where the legal representatives from all the respondents and the applicant are busy discussing this application. We have made it clear that we are opposing it. We want to proceed with the hearing next week so that this matter can get to finality. It is quite strange that we received this application in this later stage after we've filed all the papers. It really sounds opportunistic that perhaps one is looking for more information from that will come out of the said, for example, inquiry. So I would have thought that the application was able to stand on its own in terms of what is being claimed in the court papers. So that's where we are. And I must also mention there was also an unusual, on the 9th of July, we also received an unusual letter from the legal representative of the applicant seeking settlement, but with very, I would say, from a procurement law perspective, with very unacceptable conditions, which we have also rejected. So I thought it's also important to mention this so that members are also aware that there are a lot of things happening around this case which make it very difficult for us to proceed with our work. Next slide. Thank you, Chairperson, and thank you, Minister. Can I hand back to you?
Chairperson, that is our story. We'll take questions if there are any, but that is our story. Thank you.
Thank you, Honorable Minister, and Mr. Makoro. Honorable members, there is the briefing that we expected from the minister. Let me get your hands. I see the hand of Honorable Milam. That's the only hand I see now. I see the hand of Honorable Lorima. Masayas. I see the hand of Honorable Volmarans. Is that the only hands that we have? Okay, let's do it like this. We will have Honorable Milam, then Honorable Volmarans, then Honorable. Why, host, are you muting me? I'm saying we'll have
apologies, Chair. Apologies.
Okay, I'm saying we'll have Honorable Milam, Honorable Volmarans, Honorable Lorima, then Honorable Malinga. Then I will come after Honorable Malinga.
Chair, can I proceed?
Proceed, Honorable Milam.
Thank you, Chairperson. Chairperson, and thank you very much, Minister and Mr. Makoro, for your presentation. Mr. Makoro, there's still a number of questions that we asked months ago that have not been answered. Specifically, who were the individuals who served on, firstly, the RFP committee, the Transaction Advisors Committee, the Bid Specification Committee, and the Bid Adjudication Committees? Can we get a list of those names, please, for each of those committees? Secondly, I'm really concerned that let's call it the authorizations or the waivers that were granted by various bodies, including the DTIC, how those were evaluated. So how, for example, were the SAEP contributions evaluated? How were the ED contributions evaluated? Or were they just granted a blanket waiver and allowed to pass forward in terms of your scoring? Then it's very important for us to know how each bidder was scored at each stage of the process. What score did they get for each element, and at each stage, what were the final scores? Those that were disqualified, can we get details as to the grounds on which they were disqualified? I'd really like some clarification on something that I don't understand here. You indicated that people were disqualified if they failed to meet some of the technical requirements and some of the legal requirements, that those were grounds for disqualification. So please, could you explain to me how a bidder that does not have the necessary permits or authorizations or waivers for environmental purposes or for operating within a port manages to proceed through the process? I really don't understand how someone who doesn't meet the requirements is able to then proceed to the next stage and ultimately be appointed as a preferred bidder. You spoke about how if they did not reach financial closure by the set date, those were your words, the contract, they would not be awarded a contract. Now, I'd really like some clarity, because the minister was very, very clear when he announced this program that the hard deadline was going to be 30 July for financial closure. We've since had an extension, so obviously that hard deadline has been blown out the water. But what about those projects that were disqualified because they would not meet financial closure by 30 July, but might have been able to meet it by this extended deadline? In other words, aren't we just changing the rules to suit our own environment? I'd really like to know why no reserve bids were considered. You've indicated that some of these might fall out if they don't meet financial closure by the end of September. What's the plan to fill that gap if they don't meet financial closure? What, for example, if one of the bidders doesn't get an EIA approval or doesn't get an ESCOM approval? What's the plan to take that forward? Especially considering that ESCOM yesterday said that they haven't even begun to consider these projects. My last question at this point relates to the FSRUs that are used to support the car power ships in the various ports. Are they open access? If not, why not? Will LNG import initiatives be considered? How will they be considered? How many FSRUs are going to be in each port? And what are the impacts of that on the operations of those ports? So if I could get clarity on those matters, I'd really appreciate it. Thank you, Chairperson.
Thank you, Chairperson. Let me greet yourself, greet the colleagues and the department headed by Minister Mantashe, and then the officials headed through DG Mukwena. Chairperson, let me welcome the report, the presentation that came through the minister, as has been requested by the committee. The presentation that we have had a few months ago, there is a little bit more clarity on a number of issues that we wanted to comprehend. I just wanted to check first on a matter of clarity. The chronology of events, there's a slide that details the chronology of events where we have a number of dates just early in the slide. And there's a date that deals with when everything started. And I just wanted to check whether that date it's somewhere in 2020. I think it's August. It does not relate well with the chronology of events. I would just like a clarity on it. Is it just a miss? Is it a missed date? Because it deals with 2020, towards the end of 2020, it goes back to somewhere April 2020. That is the one clarity that I want to check. But by and large, Chairperson, as we have said in the beginning, we had to bring in the executive to come and relate and express on what transpired, how it transpired, what are the technicalities involved. By that time, the committee, we have already looked into sort of a committee or a commission of inquiry on the issues around this matter. Now, I wanted to check on whether, apart from the EIAs that were mentioned, and what we have read in the newspapers and this presentation, are we not at a point where we say, we as the committee, we have heard what the department is saying, and as we are busy with the terms of reference with regard to the inquiry, be ready for that type of inquiry as per what has been outlined, and we are in the know to start asking questions at the level of inquiry. I'm saying this because we might start the inquiry in this committee today if we go on with regard to specific questions that might be related to the matter. However, it is of interest to note in the report that the people who have initiated the question of legalities at court level are starting to send letters of retracting some of the things. Is it a matter of not being well informed or being opportunistic in this matter. I think that will be for the courts to decide. But in as far as our inquiry is concerned, Chair, I think the information that is at our disposal today, it gives us an indication on what to present, what to ask when we get to the inquiry as we have decided to set up. Thanks, Chairperson.
Thanks, Chair. I've got some questions for the Minister and for Mr. Makgoro, and I'm going to start with Mr. Makgoro. And I'll start by commenting that, Mr. Makgoro, you gave a stalwart defense of the procurement process, and you seemed shocked that anybody could even question that procurement might not be above board. Well, so you may forget that we're in South Africa where there have been legions of examples of corrupt procurement. So you may not be starting in as good a position as you think. As regards the specific questions, when it comes to exemptions, you have put responsibility for exemptions onto the DTIC. But the DTIC must have given you reasons for allowing exemptions. What reasons did they give in regards to car power? And I'd also like to know what other companies were granted exemptions by the DTIC, and what other applications for exemptions were refused by the DTIC. Moving on to the issue of the extension of bids, I didn't quite understand what you were saying. You said that you couldn't make a decision on extending the bids because you were following rules to the letter. You couldn't make that decision until right up at the end. What rules were you following, and what made you decide that you could then extend the bids? My final question, or group of questions to you, sir, is going forward, is it still a possibility that Car Power may obtain the necessary exemptions by the deadline and be confirmed as a contractor on this project? The next questions are to the Minister. Minister Reddy, the first one is, are you happy in your own mind that this procurement program was conducted in a correct and above board way? Minister, I'd also like to know whether you were aware of the DG and DDG meeting prospective bidders either at Cream Restaurant or indeed anywhere else. And then thirdly, is it customary for departmental officials to meet prospective bidders in non-official meetings? In other words, informal meetings, as this one was. The next question would be on the same issue. If the IPP office was running the process, why was it necessary for the DG and DDG to meet with bidders? And finally, Minister, there has been an allegation that a certain Mr. Makasi, a lawyer, brokered the meeting with the departmental officials, and he's alleged to be associated with you, Minister. Have you ever been associated with this man? Thank you.
Thank you, Chairperson. Greetings to members of the Portfolio Committee, the Minister, the department, the guests, and our committee staff. Chairperson, I think I am more interested in the slide that was presented by Mr. Makgoro on legal challenges and undue influence. Chairperson, I don't understand why would the applicant who ran to court to say the processes did not go accordingly, then now retract, like Honorable Volmarans has just said, will now retract and say they will wait for the parliamentary process. What does the parliamentary process have to do with legal issues, judiciary? Are we now overseeing judiciary, Tina, here? So my chair, maybe I'm a bit lost, because there was so much noise about this as if the department is in the wrong. And by this person who went to court, now this person wants us to be, I don't know, my silent witnesses or equally I don't know, I don't think, Chair, and for the inquiry, because the inquiry was mainly because there was noise. Do we still need this inquiry after this presentation that has been made to Mr. Makoro to us? Thank you very much, Chair.
Thank you, honorable members. Before I give to the minister, I think it will assist us as a committee to just bear in mind of the two things.
Chair, I have raised my hand, man. I thought
you see, when I finished with the members, there was no other hand. I even said I'll come after honorable. Can we all stick to the rule? I'm giving you, but I won't do it next time, honorable members. When I'm close, I'll have to give back to the minister, and then a member will do all the following list. I'm giving you, honorable Paula.
Thanks, Chairperson, for the opportunity, man. Greetings to you, greetings to the minister and the department, greetings to colleagues in the portfolio committee. One, I think I would want to appreciate the fact that the minister has been able to come before the portfolio committee, despite the fact that there is an ongoing cabinet meeting. I appreciate that a lot, Chair. Chair, I think let me start first by welcoming the presentation. And I think the presentation goes into deeper details to clarify the processes that have unfolded since the beginning until towards the culmination of the end of the program. And I think, Chairperson, we've got a challenge that some armchair critics, both in the media and this committee, take it for granted the kind of work that have been put in place to pull off a program of this magnitude. I don't think if you listen to the presentation, you take it for granted the work that has been put in by the department, by the IPPO's office, as well as other stakeholders to ensure that the program becomes a success. And I think, Chair, that the presentation also helps with regards to clearing the misconceptions that are there in the media domain around the handling of around the DMR's handling of this program. In both the media and the public and the portfolio committee, that I think we are able to clear many of these misconceptions. Part of the bulk of the misconception you would believe in the past is that the DMRE handles all aspects of the program. And in terms of the presentation, we are proven that that is not true, that the department handles a minimum part of the program. The bulk of the program is handled by the IPPO's offices, and which I think, in my own view, have done a brilliant job, Chairperson. I think we must also appreciate as a committee in terms of how the IPPO's office handled the program of appointing companies, of merging wide established companies and some established firms with new firms. And I think that speaks to the fact that indeed they take the issue of transformation serious. My first question, Chair, would be to the IPPO's office, that with the appointment of with the collation of the RFP, the work that has been done by the bid evaluation committee and the work that has been done by the Mitigation committee, and until finally a recommendation that was made to the Director General for financial approval, is there an element of undue influence, of biasness, of impartiality around all the handling from the inception of the bid evaluation committee until the bid adjudication committee, until the recommendation, and finally the announcement by the Minister of the Preferred Visas? And I think one of the things we must appreciate, because I look in details around the RFP evaluation criteria, and I must say, Chair, that as a member of this committee, I believe that due diligence was done with regards to all aspects of the program, both when you check at the technical, legal, financial, and economic development. You can tell that due diligence was done to ensure that we deliver a credible process, Chair. I also want to speak to the legal challenge and allegation of undue influence, and say, Chair, that we hope that the courts will finalize the matter in due course, and hope that when the court will be able to expose wrongdoers in the program and those who not only hold ulterior motives, but who also have a sinister agenda around the program, Chair. And I want to say to this portfolio committee that an allegation of undue influence is not undue influence on its own. An allegation is merely, but just that. It is an allegation until it is tested and it can be proven that it is true. I guess we'll never know, Chair, what would have happened if DNG Power Holdings had been appointed to handle this massive project. Because I feel as a member of this committee where I am seated, that we are dealing with a matter, or I do not want to term it a sole loser, but I don't think we would be entertaining this matter to the extent to which we are entertaining it, to an extent of even establishing a committee inquiry if DNG Power Holdings had been appointed to handle this massive project. And I think, Chairperson, that we must also be cognizant of the involvement of various stakeholders in this whole project. That is not only DMRE that has been handling this project. We have at the IPP's office, we have at ESCOM, we have at National Treasury, we have at DTI. And it will be near impossible, Chair, and unfair to only hold the DMRE accountable for the whole program when they deal with only certain aspects of the program. And Chair, that it is quite puzzling that a particular bidder would make an application that it will have to be appointed in place of another bidder. Yet the very same bidder wants to cast doubts and aspersion on the program, yet want to replace a certain bidder in the same program. I think it's quite unfair. I'm wondering on my own, Chair, whether we're not dealing with what many would term as sole losers, that a certain bidder loses to another bidder and now wants to throw the whole process into doubt. Because I don't think, I think with the explanation given to by the minister, given to by the IPPO officer, where I am seated, I'm satisfied that due diligence has been done. And I'm glad that Mr. Magoro said it explicitly from the IPPO officer that there was no undue influence in the process. And it is quite puzzling that some of the members, without any basis, would want to cast aspersion on the standing of Mr. Magora, to an extent of even calling him a stewardship of defense. If wrong has not been done, wrong has not been done. Because the misconception out there, which you must clear, is that every time when there's a big project that is out, there are those who want to say the process is corrupted, even when they don't have documented proof that the program is corrupted. Many in this committee are asking for certain information, yet they've satisfied themselves even before having that information in hand, that there's a sinister motive, there's corruption in the program. I think it is quite unfair. Their assertions are unqualified at most. So I think the explanation given by Mr. Magora to me suffices, and I think due diligence has been done in the program, and people must allow the program to move forward without any hesitation. Thanks, Chairperson.
Okay, before I go to the minister, let me just put these following issues, honorable members. First, the person who is here is the minister and is allowed to be here and to bring in anyone that he, in this case is a he, that he thinks will assist the committee to have a much more broader, open understanding of development. And therefore, questions directly goes to the minister. And the minister then can be able to relate to the supporting person, in this case, Mr. Magoro. Mr. Magoro is not briefing the committee, is there as a support system to the minister. It will be the minister then who can refer Mr. Magoro. If he had carried a legal person, it would have been a person who is supporting on legal or whatever. So I just wanted that so that we don't put as if we have called, because tomorrow it will come in and say we were briefed by the minister and Mr. Magoro. We were briefed by the minister. The minister then decided that to help the committee to understand the technical part of it, it will require a person who has got a little bit of expert opinion or broader knowledge. Let me also deal with the second thing. I must say it now, honorable members, when we are done with the minister, we will have our own chance to go back and say, based on this briefing and the fact that we have agreed that we will take the inquiry route, what will be the basis, the approach of that inquiry? Secondly, what will be the terms of reference? What type of information will be needed going forward that could be requested? So I don't want us to start to agree on something. When we deal with the minutes, we will hear what we said. Thirdly, I think I'm not saying, Minister, you shouldn't, but we must be careful that when we continue with the process, we then start as if some people are present in the meeting. The minister, I think, can answer on the basis of his understanding. But issues, for an example, around the DTIC information and so forth, I'm not opposed to the question, what would have been the response? But what informed DTIC, I'm not sure whether the minister can, or we may say when we agree on the process of the inquiry that DTIC must be the one. I'm not saying it would be, must be the one of the people because we need 1, 2, and 3. Fifthly, the minister is briefing us through also Mr. Makoro on the development of in court. At this stage, we have not reached the point where we would say, these are the people we want to invite. For an example, is the mere fact that there is a court case morally, ethically, and otherwise correct on either of the parties. We have not reached that stage. And whether on what, there is something they call the rule of artem partem rule, which says you must also give the other party the side of the story. Number 6, we have not identified if we take the route of a formal inquiry or whatever approach, which witnesses we will need. So I don't want us now to preempt the nature of that process or the inquiry. I think the last point I wanted to say, we have not reached a stage. We may, when we meet as a committee, say we still need this following information in order to assist us. That can only be done. That's why we said we first dispense with the minister. I want us to focus on what has been presented in the committee. Lastly, I hope when we deal with the issue of, and I'm not now, we wouldn't deal with the issue of the meeting from one eye only. Whether the intention, even of convening the meeting, is in line with what happens when there is a process of procurement. So some of these things will only require us, honorable members, when we deal with the actual gist of what is here. So I'm not answering on your behalf, honorable minister, but I thought some of the issues may necessarily be matters for the committee itself to deal with them and dispense with them. But I think you can, and I always say I don't limit you in responding in most of the issues that members were raising. But I think there are issues that are directly related to the department, which I think you are much more at a good standing to respond to them. But I'm giving you all the rights that any matter that you feel requires you want to have a take on, you are in this committee, you are allowed to do so. I'm giving over to you, honorable minister. It will be up to you to give Mr. Makoro a chance to clarify some of the issues. Thank you very much.
Thank you very much. The first issue is names of people who are in committee. in the majority of cases, institutions were used to fulfill specific responsibilities. And I think the fact that we give you names of institutions is sufficient because it was an institutional responsibility that was given to either Ernst & Young and Ramu and Zisi, Lidwaba and Mazwai and so forth. Those are institutions. So we can't break them into names. Now, we're giving you the institutions. And committees. I'm sure when you have your inquiry, such committees will be called before the committee. Because there's something that is important about people who are going to go through a legal process, the protection of witnesses, that we can list all the range of witnesses and open them up for some visits at some times. My own view is that these committees, they should be invited if you want information from those committees to the inquiry. I'm going to ask Mr. Makoro later to talk to the question of score for each bidder at each stage and why were bidders disqualified. Now, I think he may be, if it looks as it looks on the surface, is that there was a process, bidders were evaluated, and they were given scores, and others went through and at various stages. And then I think if we want to give scores of everyone, all the total number of bidders that applied, and give the scores of that, I don't know if Mr. Makoro is having that information readily available, but I would imagine that when we are called to the inquiry and we ask that, we'll be able to show that. Closure of financial changing rules as we, for our environment. Now, when you run a process, whether it's this bid or another bid, you adapt as you go so that you conclude the process properly. The process doesn't have primary intention to exclude. The primary intention is to ensure that people are given opportunity to do what they can do. And if there is a request, as was explained, by the bidders to say, please, a number of them make this request, please give us some extension, and a month extension is given. I think it can be explained why was that extension given, but it's not changing the rules. You are adapting to a situation as we go with that situation. How to fill the gap with others? This is an emergency procurement, actually. It's not like adding volume to the grade. It's emergency procurement. And therefore, if we have other bidders who are failing, ESCOM will be expected to take energy from those bidders who have not been excluded. And if we must actually run another process to fill the gap, that process will be run. There are questions about car power shift. I always argue here, and that is what makes many people argue that I'm protecting car power shift. I have no reason to protect because I don't know who they are. Actually, I don't know who the South African shareholders are in the car power shift because I didn't run the bid. But the reality of the matter is that if you have a process and you give 11 bidders as successful bidders, and we isolate one for a bidding, something is actually very questionable. The 11 bidders were bidded. We've given them contract similar, same period, but you isolate one for a bidding. I think there's something strange in that approach in dealing with any of these things. So my own view is that car powership has been given as one of the bidders. You find that the Department of Forestry, Fishery and Environment say we're not giving you environmental certificate. And people who are involved appeal that decision, not the department, not the department. People appeal that department. No, it's an unfair decision. We're appealing it. Now, you want us to come here and argue on behalf of Kaposh. We're not. We can argue for the program and in favor of the program. We can't argue for a particular bidder. We can't. That's why even in the appeal on the environmental issue, it is not the department that appeals. If I read properly, I think it's business people and the business associations in the coastal area where the bids were located. It is them who are actually appealing. And from where I'm seated, I want to give them, in that process, space to unfold and come up with results. And when processes are subjected to particular legal processes, our duty is to comply with the outcome. Now, if you want us to debate and argue for car powership, you are being unfair to us. It's a bidder that we will assess and give them as one of the winning bidders. Now, on the chronology of issues that were raised, I think we are referring to the date in March, which says on 18 March, 11 preferred bidders that were announced. I think it's 2021 because the bid submission were closed on 2020 December. They were announced in March 2021. So you are correct in that. People no. Well, the procurement about what? The procurement was about what? That's why we issued RFI, we issued Section 34 ministerial determination, we issued RFP, process were conducted by the IPP above board. And I think, let me make this point, that it is quite dangerous when you lose a bid, you throw mud to the process. And what I think people should have gone to court for is to challenge aspects that they think that they were unfairly treated or anything. But to cast aspersions to the process is dangerous because it seeks to discredit process into the we're going to deal with a bid window 5 now. It will still be assessed. IPP is running that process and so forth. Now, if we allow the mud to be thrown at IPP, we are going to find it difficult as we move forward in running any other process. Now, people throw here their suspicion. There's a new head of IPP, Mr. Magoro, you see. Now, he happens to be an African. And many people, throughout the discussion and media statements, didn't believe that we'll have an African running that office. He is competently so. So let's not try to discredit the person and not look into the process thoroughly.
Chair, on a point of order. Chair, point of order.
And hold on, Minister, what's the order, Honorable Mele?
Chairperson, the minister is trying to racialize this issue. No one has pointed a finger at Mr. Makoro. No one has said Mr. Makoro has.
But this is not a point of order, Chairperson.
May I finish my statement, please?
Honorable Mylan, when you come back, you will clarify because it's a debatable. I didn't hear the minister raising that it is a race issue. So
he spoke to the effect that Mr. Makoro was an African gentleman, and that as such. May I finish, please? Chair, may I finish, please, and then you can rule.
There can be no rule, Mr. Mylan.
Honorable Mylan, I'm the ruling. Wait, Honorable Minister, make my work easy, please. I'm ruling on the statement that is making a race issue. I'm saying when you say somebody is an African, I don't say anything that is becoming racial. So I'm also protecting you that it is not a matter that when the word African is being used, it is then looked from a rest point of view. No, it's not an order. That's what I'm trying to say. Why should I allow you to continue?
May I finish explaining why I asked you to rule on
Chair,
this
point of order on Honorable Mailam, so that we allow them.
But are you overruling the chair?
Honorable
We have ruled on the matter. Honorable Mailam must give the chair.
Look, I'm saying from where I sit as a chair, I've made the ruling and I've stated why the ruling I'm making. So
you did not allow me to make my case, and that means that you were ruling with an incomplete set of facts.
No, I can't make you complete a racial statement. That's the point. I'm also trying to protect you. So I cannot allow the meeting to degenerate on a race matter that was not raised.
Chair, the minister raised the fact that Mr. Makoro was being targeted.
But Mayland is out of order. The made the ruling.
I will go and listen, Honorable Maylam. When I'm saying where I listen, the minister said Honorable Makoro is new and is an African. I don't see anything wrong with that statement. If you feel that statement it is wrong, it would have been better if he had qualified it by saying if he was Indian or African or white, then that would have been a racial connotation statement. He never compared it to something else. That's the point I'm trying to say. Can you respect my ruling?
Chair, I'll allow your ruling to stand. Whether or not I respect it is another matter.
Can you continue, Honorable Minister? I want to focus on, you see, that's why I was saying, can we focus on the substantive issues?
Chair,
continue, Honorable Minister.
Also through you, Chairperson.
Honorable Lang.
Yes, Chairperson. I think also maybe if you can just discipline some of the honorable members. I think everyone has to speak through you. So let's not ask members.
I agree 100%. We all know that. Please, honorable members. I always tell you, I've never done a child care exercise. All of us here are adults. So please, I don't have an early childhood development course. So make my work much more easier because I'm dealing with all of us who are adults. We know, I always say this, we know what's the purpose of being here. Continue, Honorable Minister.
Yes, so the point I'm making is Mr. Makoro is giving us a detailed framework of the process followed. It is dangerous, I'm making this point, to target the man, not the process. You don't play the man, you play the ball. Let me proceed and say the reasons for the expansion, the exemption by DTI, I don't think we can answer those questions. DTI receives a project and maybe an application, and they look into it and give reasons for that, but it is DTI who gives those reasons. It's DTIC that gives those reasons. The minister, was the bid transparent? I've answered that. Was I aware the DG and DDG meeting somewhere? No. Simple answer is that no. We have an office there, and anybody want to meet us is expected to come to the office that is given to us by the state. So I was not aware of that meeting. I read of it thereafter. Marcus, my associate, many of you will be surprised that I never had any dealings with Marcus. The only dealing I had with Marcus was, and I came to the office, and I found 2 letters in the office. One was his expulsion by my predecessor, and his letter of resignation. When he wrote to me to say, yeah, I must clarify the expulsion, I said to him, in front of me, I have a letter of resignation from you. And then the matter was closed. Beyond that, I never had any dealing with Marcus. So I don't know what an associate is. If an associate is anybody we have spoken to, maybe I will understand. It means everybody in this committee is my associate. But I never had any dealing with Marcus. Actually, I have never been to a meeting where Marcus is part, whether it's on their side or with our side. So I don't have an associate with Marcus. Why the applicant retracts and want to wait for Parliament? You see, when you want to scuttle a process, you use any rules that can delay the process. We have many examples of such issues in society. But if you want to scuttle a process, you scuttle it because it must be you or nobody. Biblically, if this is your child or not your child, cut this child in half and give him my half and that half. Because not your child will say, cut him in half. So why does he want to wait for parliamentary process? It's not his process, but I think he's trying to delay anything to scuttle the process. Presentation gave the details. And I'm sure we gave you this presentation openly and gave you the details of what the process is and the chronology of events. You can scrutinize that, call us back if you want to. Hopefully not on a Wednesday. We'll come back here when you invite us. And the question of the combination of companies used is a deliberate exercise on the part of the IPP to actually ensure that we are managing the question of the demographics in various areas of competence. I don't want to talk to issues where people make statements and make observations. I don't want to get into that. But actually, it's quite interesting to me, but it's a court issue where a bidder wants to be appointed and say, fire that bidder, appoint me. That is very curious for me. I think we provided the information that you needed. Mr. Chairperson, you are correct. Ms. Magoro is a support structure to my submission to you. I want to use this space to give him a few minutes to close whatever gaps I have left in answering. Mr. Magoro?
Thank you, Honorable Minister. Good morning again, members of the Portfolio Committee. So I will just go through some of the questions that maybe the Minister has not touched on. The first one, I think, from Honorable Malaham was around the individuals who served in the different committees. That those names can be provided. Suffice to mention that there is an audit that happens after this process by the Auditor General. So the process is also overlooked by the Auditor General, and they will go through the same process to verify. But if there are names, if the list of names is required, I wasn't aware that there has been such a request. We can make those names of the individuals from TAs to BAC members available to the committee. The Minister has already touched on the waivers by the DTIC. We are not party to that process. The DTIC makes its own ruling based on their own assessment of the market, and they decide whether or not to grant, or even to grant a partial exemption if they deem fit. In this program, they've granted exemptions in a number of areas. It's not just the car power ships. I've already mentioned the inverters for PV farms. They've also granted exemptions for partial exemptions on PV modules, because they subsequently realized there's not enough manufacturing capacity in the country. So it's nothing new that they grant exemptions. It's entirely an independent process that they undertake on their own. Then there was an issue around the economic development. So economic development scorecard is it has a minimum threshold. Like I mentioned, the 49% ownership by South African entities, the BEE ownership, black people ownership of 30% minimum. So bidders are incentivized to go beyond the minimum by getting more points in the competitive ranking process. So if a bidder, for example, has more than 49% South African ownership, or more than 30% black ownership in the entity, they get more points. Therefore, they get a better chance than the other bidders. There are 7 elements of the ED scorecards. We can make that available to the members of the committee as well, covering issues like local content, skills development, and all of these are made clear upfront before the RFP goes out. But if there are exemptions, as I said, the bidders might realize that there's not enough manufacturing capacity. They're allowed to apply to the DTIC, and if that application is successful, we'll then communicate to all the bidders, and that becomes a briefing note to the RFP, which means it changes the original requirement that was in the RFP. How each bidder was scored, that information is available. Obviously, it's subject to confidentiality, but we can make that available, and it has been part of the court papers that we submitted to the court, so that can be made available as well. Disqualification, it's important that I mention here that each of the 11 projects that were disqualified, we have written to them and communicated exactly on which aspect of the RFP they failed. And they were all allowed to have an engagement meeting with us where we explained further where they failed. And beside this one bidder, all the other bidders have actually accepted the decision of the technical advisors and the bid evaluation committee. Authorization and permits, it's nothing new. It's the same process that we follow all the time. NERSA can only issue a generation license after the preferred bidder stage, and that process takes place immediately after that process, after the announcement of the preferred bidders. Similarly, ESCOM only issues the connection budget quotations after that process, and that's another permit that they need to come back to us for us to then sign the contracts agreement with them. Similarly with the Ports Authority as well, they will have to come back to us with the approvals before they can reach financial close. There was a question again on financial close. Yeah, there were no reserve bidders in this case. That was the decision that was taken up front, that there will not be reserve bidders for this program. If we want to have reserve bidders, we must again indicate in the original RFP that for this program there will be reserve bidders, meaning if the bidders falls off, then other bidders, subsequent bidders in the ranking will then come in. But this was not provided for in this RFP. So whoever does not reach financial close will not proceed to sign the agreement document. Yeah, the minister already responded to how do we fill the gap if some of the preferred bidders don't reach financial close. At this point in time, the only option is either to go out for another program or fast track the subsequent programs. The FSRU, I cannot comment on the current state. There are engagements between the different bidders who are using gas technologies and the TNPA. And that process, as far as I understand, it's still ongoing. And where they are and how many FSRUs will be allowed in the ports, I don't have that detail. I think TNPA and the bidders themselves are in a better position to answer this one. And then from Honorable Vormarans, I think yes, there was an error in the slides. It should be 2021, not 2020. From Honorable Lorima, the first question was around the exemptions. I don't have reasons why DTIC gave the exemptions that they gave to all the applicants, but that information is detailed in the letters that DTIC issued to the applicants, and we can make those letters available. I just don't want to try and interpret what the reasons were, but the letters are available. We issued them as part of the briefing notes as well. And it was not just the car power ship, they've given exemptions on inverters, as I mentioned earlier, and the PV modules. And then the extensions, yeah, so the reason for the extension, why, when I mentioned that there's a governance process, so the RFP itself indicated what the closing date for bid submission was. Because this is a material change to the RFP, we needed to make our recommendation to the BAC, and the BAC had to independently evaluate the reasons for asking for an extension. And only after they are satisfied that that extension was warranted, they then recommend to the accounting officer for approval. So the reasons were mainly coming from the bidders. The bidders were concerned that, and I've already touched on this, the program was complex to structure it from the technical design and as well as the financial arrangements around the funding needed more time. And we looked at the request, and based on the justifications that were given and the fact that December was mainly a dead month, so we decided to support that request, and then it went through the governance process before we could communicate it to the market. I hope that answers that question. Then the question around car power ship and their environmental authorization. Unfortunately, that is the question for the bidder themselves. We cannot respond because we're not party to licensing and authorizations that the bidders have to achieve before they can reach financial close. So is the funding, confirmation of the funding arrangements with their lenders. Yeah, Honorable Malinga, I am not sure why the applicant want to wait for the PPC process to be concluded. It's quite strange that if there was a case from the beginning, the case should be able to stand on its own. without relying on the outcome of other processes. So we are as confused by this recent application as you are, Honorable Member. And then from Honorable Kula, there was a direct question: is there an element of undue influence in the process? I think, as I've shown in the presentation, the answer is it's a no. It's not possible to influence the process. Not even myself can influence that process. As I've indicated, there are so many checks and balances. Even the different TAs or technical advisors, they work in isolation. They all bring the outcome of their process in one meeting, and everyone explain why the findings, if it's a failure point, they come and justify why they believe a particular bidder failed, and there is interrogation, and until the bid evaluation committee is satisfied that it is indeed a failure point. So the question of undue influence is very, very improbable in the program, in the way we have structured the process. I think I've addressed all the questions, Minister. Back to you. Thank you.
Honorable Chairperson, I want to caution Mr. Makoro not to overcommit on all available information. There are processes that are undertaken by the committee. If in those processes you are asking for information, we'll provide it to that process, so that if it is leaked, somebody must take responsibility. We're not going to distribute names and other things willy-nilly. If a process of parliament wants the names, we'll provide those names to that process. If you want this information, we'll provide it to that process, so that somebody must be pinned down when it is leaked. I'm handing over to you, Chairperson, again.
Thank you, Honorable Minister. I see there are follow-up hands, and I am going to allow them. But can I make this appeal, Honorable Members? Since we started on the 6th Parliament, I've said, can we focus on the issues that can assist this committee and try and avoid? I know when I make a statement or I say something that what could it result on? Can we assist this process and make sure that we contain any other matters that might relate to our own standing and do what we are supposed to do to the best interest of our country? I want to allow Honorable Lorima, I see he's making a follow-up. I want to, and then Honorable Mailam, is there any other hand or follow-up? In the absence of that, Honorable Lorima and then Honorable Mailam.
Thanks, Mr. Chair. Minister, thanks for the answers that you did give. Although you didn't answer all my questions, I'm glad that you said that you weren't aware of the DDG meeting of prospective bidders. I think that's an important answer. Also, your response on that, Mr. Mantashe, I think it's important to have that on record. One of the questions you didn't answer was, I said to you, Minister, are you happy in your own mind that this procurement program was conducted in a correct and above board way? So if you could just tell us what your feelings are on that. Minister, when you used the straw man argument about people criticizing Mr. Makoro for being an African, that does one thing. That makes it look like you are introducing a red herring, and it makes it look like there's more to this issue than an above board process. I think it will lead some people to think that you're hiding something. You also, Minister, launched an attack on people by saying we're picking on one company. Well, let me refresh your memory as to why we are focusing on Coal Powership. It's a massive long-term contract for what is usually seen as an emergency short-term power supply source. There's also been an illegal environmental authorization. There's also been an unexplained meeting with top officials. There have also been allegations of corruption. That's why we're picking on it, Mr. Minister. It's called oversight. Thank you.
Chairperson, I would also like to comment on a couple of issues here. The first is that our inquiry has nothing to do with any court action, and indeed, at no point did any of the information that we requested have anything to do with the court case or the processes that are being undertaken in the courts. This inquiry is an independent inquiry of Parliament, which is part of our responsibility as defined in the Constitution. It's part of our oversight role. And Minister, it therefore blows my mind when you make a statement that my answer should be sufficient. I'm sorry, Minister, you don't get to decide what is sufficient for an answer. You are accountable to Parliament. And so if we ask the question, we expect an answer. And so going back to what my question was that you then tried to obscure or obfuscate, and which Mr. Makgoro then kindly said that the information would be available, it was, who are the people sitting on those committees? And the reason why I asked that question is because precisely of what Honorable Lorimer has just said. There are allegations of undue influence. There are allegations of corruption. There are allegations that people had connections. And so we are trying to determine what those connections are and who was involved. And that is necessary, and that makes it necessary for us to know who is sitting on those committees. And it doesn't help, Minister, when you say, oh, my answer is sufficient for that, or I've given you the companies that are involved and that's sufficient information. No, Minister, you don't get to make that determination. I'm sorry. Secondly, Minister, I would like to point out that I don't believe anyone attacked Mr. Makgoro at all. That Mr. Makgoro was giving a presentation and we went after the issues in that presentation, not him as a person, and no one called him as a person into question in any way whatsoever. I do have a concern, and this is where I would like a follow-up question. And that is, when you made a determination, when you announced the preferred bidders in March of this year about the hard financial close date of the end of July, I haven't clarified in my mind yet, and I would really like an answer as to how you can say this is a hard close date. This is the date at which everyone must have their ducks in a row. They must have all their documentation sorted. They must have all their financials. They must have all their authorizations by this date, by the 30th of July. On what basis then can you suddenly shift it to the end of September? And as a secondary question, is it going to be shifted again? We're 30 days away. We heard from Mr. Makgoro now that only once financial close is reached can other authorizations be issued. And he mentioned the ports authorization. He mentioned the ESCOM, and I think he was referring to the power purchase agreement. But there are other authorizations, their grid connection authorizations and the like. All of that would need to be in place before that financial close date. So my question is, are we going to see another extension? And on what basis can you just say, well, I'm changing the rules? On what basis can you say, I'm changing it from 30th of July to 30th of September? I really don't understand where that comes from. Yeah, let me leave it there for now. Thank you very much.
Honorable Minister.
Thank you, Honorable Chairperson. I'm trying to open my camera because I want to see.
Honorable Minister.
Thank you very much, Honorable Chair. I think I've said this over and over, that the process was correct and above board, transparent. That's why, Mr. Lorema, I refer to the stages, RFI, ministerial determination, RFP, all those processes were transparent and open and gave access to the public to actually interrogate the process. So, my own, as far as I'm concerned, the process was correct and above board and transparent, had all checks and balances. That's my answer. I'm repeating it, by the way. Red hearing on Makoro, it's not red hearing. I get worried when people get nervous when we talk about race as if they're not in South Africa. Race is a factor in South Africa and it will remain a factor for a very long time. Now, if people become nervous when we talk about race, that worries me more because racism, Mr. Lorema, is not what you do. It's more complex like that. It is sometimes in the subconscious mind of people. And when people jump up and down, that subconscious reaction comes to the fore. So I don't want us to say something is hidden. I had nothing. That's why I'm here. You say we are focusing on one company because there's long-term contract and there were meetings and so on. I have not come across the information that the meeting was about a company. I have not come across the long-term contracts being for one company. It is about the whole bid. Every company, is one of them, 11 of them, have the same length of contract. That's why I'm saying when the focus is on one company, it communicates a very complicated message about our view, our approach, and the attitude towards that company. Because long-term contracts is for all levels. The meeting, I don't know, I was not in that meeting. I have not had any information written, affidavit, and other thing, that meeting was about a car powership as a company. I know that there was a meeting which I was not part of, and so forth. Now, and therefore I agree with Mr. Miller that this process does not have anything to do with the court process. That's why it is strange to ask for postponement of the court process because there's a parliamentary process. There we agree. Let me talk about this. I was not told that I'm coming to an inquiry here today. I was told that I'm invited to the portfolio committee. I was not told that I'm coming to the inquiry. Therefore, when I give answers, I can give answers and say, I think we've given sufficient information. And I put a rider, which you ignore, Mr. Miller, that says, when there is a parliamentary process that requires the names, we'll have to submit those names to that process. And I explain why is that important. That is important to protect the individuals. Because we can distribute the names here, everybody have it. And the next day, we read it in all newspapers that Mr. So-and-so, 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 we open people up. And I'm repeating, we will give the information to the parliamentary processes anytime they want that information. But what we should not say, it will be available freely. It's not available freely. It will be submitted to the process so that the process can still protect those men. Differential closer was shifted, and it was a technical exercise, basically, not a political decision, because ESCOM, who is the ultimate procurer, was not ready. That was the explanation given, is that ESCOM, which the ultimate procurer, was not ready. And therefore, the extension of that deadline was in the interest of that procurer readying itself to be part of the process and conclude the process. Will there be another extension? There is no such a proposal on the table at this point in time. Thank you very much, Mr.
Okay, thank you, Honorable Minister, for the presentation to the committee. I always very careful to start processes before they start, and I appreciate your acknowledgement of what you made as a commitment. I want to start there. That as the committee continues to do its work in the context of continuing with an inquiry or what, that you will always be available. The normal procedure, like I said, even if is that the executive authority must be given an opportunity to give a broad clarity and undertaking, and based on that, this committee will have to go back now and start the process of what next, what approach will be used, and it might, in the process, come back to a point where we say we now need the minister because we are now officially on this process. So your commitment. Secondly, let me say to honorable members, I allow all these things because when you deal with such matters, there is a lot of emotions and other things. And when you try to put things in order or in a process, it will sound like you are trying to gag people not to raise issues they wish to raise. We will come back, honorable members, we'll come back with a date. On that date, informed now by the presentation by the minister, we will start the process of the approach that we are going to take, of the timelines that we will put in place, of the categorization of information that is needed. I can't say now, Minister, the committee, because the committee has not met which information it might ask for. But members in the committee, in the process of inquiring for some more information to prepare them for that process of eventuality, they may ask for. But at this stage, only when we have met as a committee, it might come back to the department and say it requests this and this particular information. At this stage, yes, everyone could be satisfied, dissatisfied, but we have not reached a stage where we would say this is a collective view, this is a point of disagreement, or whatever the case that might be. We are just still at the initial stages of this exercise. But most definitely, we think that even the information provided, it gives sufficient grounds for us to have a better understanding of what has been happening, whether we agree with that or not, whether we still need more of this information, that will only be clarified at the city. We will try our level best to put as much closer a date for the committee to deliberate on the next course of action, but also and who are the required witnesses, if there will be many or how few. If Mr. Magoro, I'm just making an example, if Mr. Magoro now is needed more as a witness based on the process followed, that can only be made and be determined by a committee in its discussions and decisions. I think on that note, let's appreciate your time. We will take note of your concern, and we don't want to also. It's never our intention to put you in a situation where you can choose which to attend, which not to attend. You will acknowledge that the dilemma will only have got 2 days, mainly as committees, which is Tuesday and Wednesday. And at times, Tuesday is the one that we understand you are part of the National Coronavirus Command Council, which but we will continue to interact with your office. As the minister and your team, you are allowed also to make a proposal of a possible date, but between the 2 days, which is Wednesday and Tuesday. But we will try, because our normal days anyway of meeting is Tuesday. Lastly, I must say, with the load of work in front of the committee, we may even have to consider days that are outside our normal day or normal days of Tuesdays and Wednesdays. On that note, we thank you very much, Honorable Minister. For now, you are released, except if you want to have your last words of closure. You are not a judicial commission of inquiry. Don't think you are in front of Judge Zondo.
Thank you very much. I've been to a judicial commission of inquiry a number of times. So, if need be, I will appear, even if the judicial commission of inquiry. Thank you very much. We'll stay alerted and ready to come on the call. If the issue are days, let's look at times. That's all. All I'm saying is that we must be allowed to be optimal in our operation. That's all. And the portfolio committee is quite an important committee for us as a department. Thank you very much, Mr. Chairperson.
Thank you, and thank you, honorable members. Can we now go to the minutes?
And the minister is released in the department.
You are excused.
Yeah, thank you.
Okay. Can we go attendance? Number 1. Number 2. Number 3. Very good trip, boss. Number 4. Number 5. Wait. Okay. In the absence, is there any move of the minutes?
Chairperson.
Yes.
Hi, Chairperson.
Oh, Honorable Bilangolu.
Yes, I want to make my correction for my initials. It's not H Belankulu, it's JH.
Okay, noted. JH Bilangolu, I didn't note that is H. Any move of the minutes with the slight amendments? I hope you know the song that says Tina Solala.
I move, Chairperson.
Okay, thank you, Honorable Bilankud is moving the minutes. Any seconder?
A second, Chair.
Thank you very much. Any matters arising? None. Can we go to the next set of minutes, Ms. Boss? We know Honorable Mashaula is dark and handsome. Can we see the minutes?
Yes, Chair, I'm trying to flag the minutes. Just a second. Can you see the minutes, Chair?
No, I see them on the 25th of August, but not the minutes themselves.
Okay.
The item minutes. Am I the only one?
No, you're not.
Yes, attendance.
Can you see them, Chair, now?
Yeah, I see.
Okay.
Attendance. I know Babu Bilankud is going to say is J.H. Bilankud. I'm worried, Ms. Boss. With these days, things happen. I'm worried. I see the apology of Honorable Sungula. For quite some time, I've not had the apology or anything from Prof. Can you check with him? I know it's not our duty, but just to check, is it still okay?
We'll do that, Chair. We've been sending messages and he doesn't pick up the calls. We'll make a follow-up again.
But also,
Pardon?
Chair.
Yes, ma'am.
Yeah, I'm saying. Yes.
Okay.
I'm saying also for consistency's sake, all the previous minutes have recorded Prof to be absent, but here there's just nothing.
Oh, okay.
We'll correct that, Chair.
Okay. Number one. Number two. Number three. Number four. Number five. Number six. Oh, any move off the minutes?
I move for the adoption, Chair.
That Mr. Kula.
Without a doubt, yes, Chair.
Thank you, Honorable Kula. Any seconder?
I second, Chair.
That Honorable Volmarans.
That's correct, Chair.
Okay, any matters arising? Honorable members, I can safely say all the outstanding, I hope the Secretary can confirm, I have not seen it myself. Just before we started the committee today, she has confirmed that NERSA has provided the requested information, and we will then immediately after this, I'm sure you will get the information to be distributed to you. Is there
That's correct, Chair.
Is there any other matter, boss, that I need to add, or must I outline now the amendments to the program?
Yes, Chair. Can you please outline that?
Okay, if possible, you can flight it, but for now, honorable members, on the issues, let me start there that we had requested that they be taken into consideration. One of those is the I just wanted to see the date. There were two issues that needed to be considered. Amongst those was the yes. Boss. Yes.
Can you see it now, Chair?
Yeah, let's go. We are past 24. We are now on the first. It means we need to get anything after the first. Yes. There it is, honorable members. We have restated the issue of the update on fuel prices and the state of our refineries. Painful truth is that last night the fuel again went up when it was initially a process. Same day, we are dealing with virtual public hearings on the written submissions. So is the case again on Wednesday, the 8th. Then we are supposed on the 10th, on Friday, to start public hearings in Mpumalanga, according to what members have guided us. Mpumalanga, those are the two areas, that is Woodbank, Middleburg, as well as Mpumalanga Strait. Then there will be a briefing by DMRE, Transnet and SAPS on challenges with regards to crime on the gas pipeline and the rail infrastructure. Then there will be a consideration of the desirability in terms of the gas amendment. Then we will still be dealing with the bill again on Tuesday, the 21st. Subsequent to that, we will be having a briefing by SAF on its PAPPs and the financial year strategic plans 2021 to 2022 and 2021, 2026. We will then have again another briefing on the 28th on the by NEXA. Same on the 29th, that is on Wednesday. We will have the quarterly performance reports. Then we will have public hearings on the 1st of October. That is Gauteng. Then on the 5th, It's a briefing by Auditor General, and then the briefing by the department on the annual report for 2020-2021. Then we'll deal with the entities on the 6th. Then Thursday, it's again a continuation briefing by the entities. So is Friday the 8th. Then on the 1st, there's a tabling of the draft ARRR, and then consideration and adoption on the 15th, that is on a Friday. We note that there is a possibility during those periods that there will be constituency offices or constituency period. Then we will start on the 18th of October with the gas amendment bill, public hearings, Richards Bay, Durban. Those are the areas we could think of. Then we will then have Cape, Eastern Cape, which will be Great Dog and Tabeja. And then Northern Cape, those are the two areas, that is 24 and 25, Katu and Kimberley. Then to the Free State, which is Bloemfontein and Sasolburg. Sasolburg is put together with Vanderbilt because of proximity. Then there will be Western Cape, Beaufort West, and Mossel Bay and Saldanha. That is how the program will look like. In between this, we'll have to put the day or date for the discussion on the RMIPPP, whatever, the risk mitigation independent power producer inquiry. And then from there, we may have to need to develop an approach as well as a separate program that will have to run either parallel or within the program that we are having. The last thing I must say here, honorable members, is that I will be interacting. I tried even after this meeting with the office of the House Chairperson so as to fast track this process, because it is a cumbersome process. It needs to be canvassed. And we will urge also members of this committee in their respective political homes to do their own work to ensure that such public hearings are a success. Otherwise, if there is not much appetite out of this process, it could also border on, I don't want to say wasteful expenditure, but also a matter that says all things are fine as they are being proposed as amendments by the department, and therefore there's no problem with regards to that, except if us as members and those who have made submissions take some of these issues into consideration as the ultimate reflection of what is the interest. Any matter with regards to the program as submitted, honorable members, it's what we adopted. It's that we have factored in some of the issues that members have requested us to do, including the provinces they think will need to be taken care of. It's a new, I see the hand of Honorable Mylem and then Honorable Mashaule.
Chair, thank you. Chair, I have two concerns. The first is on the 21st of September, you've got on the program the motion of desirability on the gas amendment bill. And it strikes me that we shouldn't be considering whether or not that bill is desirable until we've concluded the public hearing process. I think that it's putting the cart before the horse to do that motion of desirability so early in the public hearing process. That's my first concern. My second concern relates to the venue selected in the Eastern Cape, namely Cradock. I would have thought that it would be much more suitable to do that in Graaff-Reinet, which is the sort of heart of the hydraulic fracturing and shale gas industry in the Eastern Cape, and it's certainly the area where There has been a lot of discussion around shale gas and hydraulic fracturing. So I'm just raising that as a concern, Chair.
Chair, thank you very much. I wanted to raise the point that Honorable Malam raised around the discussion of the desirability of the gas amendment bill. I think it's correct, Chair, because if we were to arrive at the point where we say it's not desired, it means we must not continue. So I would think that the desirability should come at the end when we have interacted with all processes and come to a conclusion whether it's desired to have it moving forward or undesirable. I think I would have to support him to say, let it come at the end, Chair. Thank you.
Okay, Ayanda, you want to say something before I say something?
Yes, Chair. No, members are correct in that. I think that was the mistake on us. It should come to the end. I think the reason that is there is when we inserted the provinces. So the MOD will come right at the end of the hearings, Chair.
No, it's fine. That you have defeated me, but my take was that we should have at the time where we agreed on public hearing started with the MOD, but I don't think it's a train smash because the mere fact that you agreed on public hearing, but I think it's an error that is not difficult to do. Let's put it as an item at last, and then we will find ways, honorable members, then of adjusting with regards to this process. The issue, I don't know. Ayanda is from Cato.
Hi.
Is from Khafre. What is that place of yours?
Cradock. No, I'm from Cradock.
Okay. So is it true? Because most of the time when we're dealing with the shale gas, we were usually taken or used to go to Cradock. Now, Honorable Milam says no, it's supposed to be Khafre.
Chair, members can decide. From what I know, it's between Beaufort West, Khafre and Cradock. So it's up to members where would they want to be for these hearings. It can be Cradock, it can be Khafre. We are definitely going to Beaufort West for Western Cape. So Mr. Milam is correct to say it's happening in Khafre, but part of it is in Cradock. So it's up to members to decide which area they want to have public hearings.
I'm really comfortable with either. We can take Khafre if there's a feeling. I don't think I can object to that or Cradock.
No, Chair, let me also support the motion of us going to have Renette with the argument made by Honorable Miller. I think it suffices. Okay. Yes.
Okay. Then let's change Cradock to Renette, boss.
Yes, Chair, will do.
Okay. Is there any other matter, honorable members, on the program? Okay. In the absence, you will see on the third part of this program, you must increase the kgs of your luggage because it's going to be a bit longer than the others, honorable members. But also let me say, please, members must indicate in advance, and those who might have problems must also indicate as such, so that we don't have challenges of logistics on the 11th hour when we are supposed to undertake the public hearing. Honorable members, there's
Chair,
yes,
Chair,
Mamale.
on the issue of logistics, we request the Secretariat to give what is due to us on time. The issue of SNTs. We did not get our SNTs when we went to Mossel Bay, when we went to Saldanha, and we did not get any clarity on that. Can they do this on time, Chair?
Noted, Mama Linga.
They were you.
And we want to get the report, what happened to that.
You
If
will
possible.
get that, Mama Linga.
Thank you very much, honorable members, for your patience and good exercise. You are now released. Oh no, what we will do, honorable members, when we go for that meeting of determination as far as the inquiry is concerned, we will forward every correspondence that we have at our disposal. We will forward also including the ones from the Speaker's office, the ones from the House Chair, the ones that relates to, or you can also bring them the legal opinion. We will also have to bring in the original presentation of the department. I hope I didn't ask the minister because that was his. If we can get also what the minister has made today, we'll try and consolidate all those documents for your own attention, so that whatever deliberations you make on the basis of an informed and clarified basis on how to move forward. We will do everything possible to make sure that you've got the necessary information at your disposal. Having said so, honorable members, the meeting stands adjourned. Keep safe, and let's meet again in the next round of the meeting. Thank you very much. The meeting stands adjourned.
Recording stopped.
Don't leave the chair.
Thank you, Chair. Chair.